Well, welcome to our session on Indonesia. And it gives me a great pleasure as a person interested in Indonesian law. I'm Professor Simon Butt from Sydney Law School to chair this session involving Bivitri Susanti, who is a lecturer from the Jentera School of Law in Indonesia. Now, before we start, I'd like to acknowledge that the Sydney Southeast Asia Centre is located on the Gadigal lands of the Eora Nation. And we acknowledge the tradition of custodianship and law of the country on which the University of Sydney campuses stand. We pay our respects to those who have cared and continue to care for country. Yes, as I said, our speaker today is Ibu Bivitri Susanti, who is a founding director of the law school, the Jentera Law School, and also an all-round law reform expert in Indonesia. I remember first meeting Bivitri soon after the fall of Suharto, when she was really one of the key kind of leading legal reform advocates and really set the scene for the Reformasi period, including the legal aspects of that, which then followed. So it gives me great pleasure to introduce Bivitri and hear what she has to say about Indonesian politics.
Okay, so thank you, Simon, for your very kind introduction. Selamat pagi, good morning from Indonesia, and good afternoon for audience in Australia. Very happy to be here in this important forum. Now, I just started my timer. I have 20 minutes presentation, and let me now share my screen to show you the PowerPoint I have prepared. All right, so 20 minutes is indeed not a long time scheme for presenting what's going on in Indonesian politics currently. So I packed many issues in Indonesian politics in two very big themes, but I believe this will help us to get the big context so we can have hopefully fruitful discussion later on. So two themes. The first is rule of law decline, and the second one is political issues leading to 2024 election. And I believe this is something that many of the participants would love to discuss more later on. So rule of law decline, rule of law indeed is a very big theme, very huge. So I have 6 issues in this theme. I will talk about judicial harassment on freedom of expression, and then denied democracy by undermining due process of lawmaking. And then I'm also very sure that there are many people who are interested in the new criminal code, and then the recent phenomenon of court capture. So not only state capture in the broad sense in talking about corruption, but we can now specifically, unfortunately, talk about court capture in the Indonesian context, and then of course corruption and human rights issues. Let me now come to the very important issue in Indonesian politics currently, which is the judicial harassment on freedom of expression. I here put on the screen the data from Amnesty International Indonesia that shows you the statistics, the number, very concerning number about how many people were criminalized using the electronic information and transaction law. This is the law that has already many victims, I would say, in a way that there are very few articles, 2 and 3 provisions actually in the law that specifically can be used by whoever want to use it. to criminalize people on the defamation cases. So I would highlight Fathia and Haris case. For those who are not familiar with this case, this is two prominent human rights defenders who are now actually in the process of criminal court trial, again using the electronic information and transaction law, because they were discussing the mining ownership in a number of mining companies in Papua, which involves the coordinating ministry on maritime and investment, Luhut Binsar Panjaitan. So this they are still in the court. I mean, the process, the trial is ongoing now, and I'm highlighting this case because they are indeed quite prominent human rights defenders in Indonesia, and they only symbolizes many other activists and you name it, anyone who are basically seen as too critical against policies or a number of high-ranking public officials and all that. They all can easily be brought to court by this law. And but that's only one modus in the suppression of freedom of expression, because we can also talk about the use of state institution, the police, armed forces, vigilante groups. Also, we have to mention to expedite infrastructure and development projects, as well as generally suppress freedom of expression. The examples will be the case in Wadas. Wadas is an area in Central Java, and there is mining, stone mining there, and the government, it's a national strategic project, and the government uses the police and armed forces to evacuate the people from the village there. And also the case of G20, I have to mention this because this is the pressure for vigilante groups in East Java, when some colleagues of mine from Greenpeace Indonesia are on their way to Bali to attend the G20 meeting some months ago. So this is something that is really important in Indonesian politics at this moment, because when we talk about democratic decline, then this is really the one of the biggest example, and also an important phenomenon to talk about the rule of law in Indonesia. And then the next issue I would like to discuss is, I call it denied democracy. We can talk about, I use the term due process of lawmaking because, and I put the case of criminal code in one sub-theme here, because I want to talk about the speedy lawmaking process undermining meaningful participation. To discuss or to deliberate a law in quick and in the short period of time could be fine as long as the participation was conducted in a meaningful way. But the problem is we cannot only talk about the length of the time used by the parliament in Indonesia or the House of Representatives in Indonesia, but we can also see clearly how the short period didn't give enough room for thorough deliberation and, again, meaningful participation from the people. I would mention, for example, the case on the law on the new capital city of Nusantara, which took only 43 days to discuss. And imagine that this is moving the capital from Jakarta to Kalimantan. And that was with very minimal participation. Of course, they call it participation when they invited scholars from many universities, but they didn't invite, for example, the indigenous people who actually live there, have been living there for tens, even hundreds of years in that place. They didn't, conduct any participation for the indigenous people in the area where the new capital city will be built. And then also, don't forget the case on the job creation law. I put quote unquote job creation because the name seems good, but actually it's not about only creating the job, but how to create the job, which is, in a sense, the law, it's very thick. It's 1,173 pages. But in a sense, it's creating job by giving more ways for the investors to get labor with very minimal rights, and also to speed up the process for investment, and also to start development projects and all that, by basically putting aside environmental regulations. And that particular law, I mean, I think we can discuss that in detail later on when we have time for discussion. But just to put very briefly there, this is an interesting, and I put as a case in the sub-theme undermining due process of lawmaking, because this job creation law was enacted in 2020, and then it was declared as conditionally unconstitutional by the Constitutional Court in November 2021. And then, with the instruction from the Constitutional Court to have to make a new law by November 2023, which is this year. But instead of making a new law, the government actually issued a government regulation in lieu of law to replace the law. But in a sense, it's exactly the same content as the job creation law that was enacted in 2020. And it was issued, the government regulation in lieu of law on job creation was issued on the 30th of December 2022. And then it was, because it's only government regulation in lieu of law, it has to be enacted by the House of Representatives in the next session, but they failed to do it, but they didn't declare it, or they didn't retract the government regulation in lieu of law, although the Constitution says that retracting the law that was failed to be enacted as a law in the next session is actually a must in our Constitution. But then again, they just put aside even constitutional provisions in order to speed up the development process. We have a flash of good news: law on sexual violence crime, and also new criminal law system under book number 1 of the criminal code. But this is something that we have to see the enforcement later on. And then one important issue is also court capture and corruption. But I intentionally, of course, chose this picture that I put on the slide in front of you, Save Mahkamah Konstitusi, because I call it court capture because indeed the independence of the Constitutional Court is under attack by replacing the Constitutional Court judge with a new one because of the decisions they made. So this is a clear attack to the independence of the judiciary. But even more than that, now the House of Representatives and the government just started to deliberate the revision of the Constitutional Court law to make that legal, to be able, for them to be able to evaluate, that's how they put it, evaluate any justices at any time and replace them at any time they wish. So this is a clear breach of independence of the judiciary. Collapsing anti-corruption commission is, we can see even clearer and clearer now. And we can see also the phenomenon that the KPK, the anti-corruption commission, seems to be used for political actions, especially leading to the 2024 general election. And then there were corruption cases involving Supreme Court justices. For impunity, I just highlight 3 issues here. There is the theme for non-judicial solution on past gross violation of human rights, which we are afraid it will be, basically whitewashing the gross violation of human rights by just giving the compensation without actually opening up the truth, which is the main purpose of having non-judicial procedure for gross violation of human rights. And then we have Papua's Paniai Human Rights Court case and also the Kanjuruhan football case. Both are problematic because we can see that the court process were conducted in the ways that violating a number of procedural law, and also there were pressure from the authorities, which resulted in the decision. And then on now I come to the second big theme here, which is the election. And I just put this very detailed schedule in front of you just to give you the context about what's going on at this time of the day. And then also the whole context leading to 14th of February 2024. As you can see now, we are actually in the process of registration of candidates of DPR, DPD, and DPRD. That's the House of Representatives and House of Regional Representatives at the national and also local level. In terms of the presidential candidates, we still actually haven't got any formal stipulated candidates at this point, because that will only happen in October, 11th of October. But now we have meetings, behind closed doors and negotiations, which we don't know, what they were talking about in the negotiation meetings. We have probably 2 or 3 presidential candidates. We don't know yet, again, because this is still ongoing because of the Indonesian system in we have direct presidential election, but we have presidential threshold for proposing the candidates. But there are 2 important issues in terms of the election. The first one is probably you have heard before that there were issues of probably changing the constitution, or other probable ways to make President Joko Widodo's term 3 times instead of 2 times, and also the possible of postponing the election. We don't know yet until when, but the issues are always going up and down regarding the extension of President Joko Widodo's term. And there were some serious efforts from the so-called volunteers of Joko Widodo, as well as 2 court cases up to now, basically pushing the court to declare that the election should be postponed. And the second issue is I put the discussion here as how President Joko Widodo acts as the kingmaker to ensure the continuation of development projects, because we can see from the political movements, political moves from Joko Widodo himself, as well as the parties, the party and other parties on negotiating the potential candidates. The issue is always about the continuation of the development projects. So to conclude, I want to highlight again, they are big themes. I fully understand that. Of course, I don't have the ambition to tell you the details of it, but I hope we can have fruitful discussion after this. But let me just highlight three issues here that rule of law decline is more apparent in the past 2 years, actually 3, 4, 5 years. But this goes hand in hand with the decline of democracy. And the sub-themes will be judicial harassment on freedom of expression, and then undermining due process of lawmaking, court capture, and human rights issues. There is also a big question mark on whether the 2024 election eventually take place. I would say it's still a big question mark. And that combined with the other issues leading to the election, there's also always this discussion whether the election is opportunity or a threat to democracy. We don't know yet the answer to this, but this, I would say, is a test to democratic resilience as well as civil society activism. I stop here now, so we have a good time for discussion. I give the forum back to you, Simon. Thank you.
Thank you very much, Bivitri, for a very interesting and I'm happy to say quite legally focused discussion. Now, we haven't got any questions yet in the chat, and I'd invite people to type them in if they would like to ask a question of Bivitri. I guess I was really interested, Bivitri, I might jump in first while we're waiting. In your discussion about the new Constitutional Court law draft and the idea that it may allow the government to evaluate whether it should remove it or evaluate the performance of a judge and then remove the judge if they think the performance has been lacking. I mean, to me, this seems like it might be an opportune time for a government that might want to engage in some electoral trickery to do such a thing, given that the Constitutional Court plays such a significant role in the rules of elections, but also in electoral dispute management. Do you think there's a link between what the Parliament seems to be trying to do now in the lead up to the election and the way that the election might run, if indeed it happens at all?
Indeed, there is a link, I would say. I would say there are two possible reasons. The first is on the authority of the Constitutional Court to review all laws. And we can see now that there are many laws actually that the government really wants or needs in order to ensure the development, the development projects continues and more investment coming to Indonesia and all that. But indeed, the second one is the election, because as we learn from the past elections, at least in the past 2 elections, we can see clearly how, at the end of the day, it was really the decision of the Constitutional Court that matters for, to decide which one is the new president of Indonesia.
Okay. Thank you, Bivitri. Still no questions, which means I get another opportunity. Talking about corruption and the Supreme Court. Now, you mentioned, I know you didn't have time, you were rushing, that there was a case of corruption in the Supreme Court. Now, it's quite interesting because for many years, the Supreme Court has been thought to be quite corrupt, but there have been very few cases that people can actually point to and say, you know, there are problems in the Supreme Court. And this has been significant because the Supreme Court is in charge of almost all of the courts in Indonesia, all except for a constitutional court and the tax court. But how significant do you think that that corruption case will be? And do you think that the corruption in the Supreme Court, because it may well be handled by the Supreme Court itself, if the case gets appealed, might be a pretty good litmus test of how judicial reform is going?
Yes, as you and many of the participants know, in Indonesia, it's very legalistic. So because we don't have alternative procedure when you know, when the court has to try the judges, then that will be the case indeed. At the end, when there will be cassation or, you know, appeal to the Supreme Court, then the Supreme Court will try their own justices, and that will be a big issue. But Simon, I see that there are already
lots of questions now. They weren't coming up on my screen, and so I'm going to have to pick some at random. I've got one from Jackie Baker. He says, "Thanks so much for the presentation. I learned so much. I want to pick up your point that there's a question mark around the 2024 election. What's the potential path that political actors could use to delay the election in your mind?"
Many potential paths. I would say I cannot give you the number now, but let me just put everything, you know, in my mind now. The first one is, of course, the possibility to amend the Constitution, and I would say there is still some possibility because there will be the general meeting or general assembly of the People's Consultative Assembly, usually in August. And I understand very well because I was invited actually in some forums conducted by the MPR that they are still talking about the possible amendment. Although they also talk about, oh, this is only for the haluan negara, the state guidelines. But I think once the window is open, then anything could happen. That's one. And then secondly, court cases. We already saw cases of Partai Prima and now also Partai Berkarya. I know it can easily be dismissed even in the appellate court, but this is disrupting the process. And at the end, there are some provisions, actually, this is some weaknesses in our general election law, that can be used, if some people want it, can be used as the reason to postpone the election. And the third possibility is actually the Constitutional Court case on the open or closed system of the proportional system of the general election. It's not directly about the presidential election, but you know, the recent cases, the recent legal reasoning for the Constitutional Court, which sometimes involves instruction from the Constitutional Court, you know, for the lawmakers to do something, it might also delay the process somehow. For example, if they rule that we can still have open proportional system, but the lawmakers, I order you guys to make a new law within 2 years. That would also postpone the election. So, so at least in, you know, the legal paths are these three, but we can also talk about other possibilities in terms of the politics, and this will also involve, for example, the budget of the election commission, and then if they declare that they cannot continue the election because probably the candidates are not probably at some point fulfilled. I don't know. There are many technicalities in terms of the organizing the election that can also lead the General Election Commission to basically declare that they cannot at the end conduct the election in February 2024. So at least I can think about this four parts.
Now, Vivici, we've got a lot of questions, so if we can answer these as quickly as possible. Okay. We might only have a chance for a couple. David Reeves asks, is Anies Baswedan now the biggest hope for a reversal of democratic decline?
Well, I cannot say so though, because his track record is also problematic in a way that, as we learned also from the gubernatorial election of Jakarta in 2017, that there were also issues of, religions used during his campaign. And actually, I'm afraid that probably at some point, things can get better with Anies, but on the other hand, the issue on pluralism and religious issues probably will be more problematic. But I would just leave one small note that Anies Baswedan might not be a candidate. Don't forget that he hasn't got any vice presidential candidate, and also now the map is changing because Ganjar was just declared on the 21st of April as the other candidate. So now some parties actually move around, and last night Prabowo just had a meeting with Wiranto, and the likelihood is Prabowo will also go. And on the other hand, Anies hasn't got enough support from the party to get the presidential threshold.
A moving feast. Last question, I think, unfortunately, and again, I apologize for all the people who have asked questions, but we don't have time to answer them. Do you have any suggestions as to how Australian actors, NGOs, business, government can assist efforts in Indonesia to defend democratic processes?
Well, first of all, I think support for civil society is really needed, because that's why I put in particular not only the democratic resilience, but civil society activism is put in test, because now I can see how the civil society is trying to push alternative ways of doing democracy. And also secondly, I think there are businesses of a number of oligarchs in Indonesia that are actually based or in cooperation with businesses in Australia. And we actually dug some information, for example, regarding some businesses linked to some minings in Papua by the coordinating Ministry of Maritime and Investment. And apparently it's linked to a number of companies in Australia. That's another, exchange of information, and then also to discuss issues like we are having now is the way for our colleagues and friends in Australia to help us with the democracy.
All right. Well, I'm sorry, everyone, but I feel like I'm cutting something off that is a great discussion. We just started getting up some steam, I think, but we're out of time. And I'll just note that the event continues tomorrow. So Politics in Action continues tomorrow at midday Australian time. But please join me in your virtual spaces and thank Vivici Susanti for such an amazing presentation and a very informative set of answers to our questions. So thank you very much, Bivitri, and all the best to all you viewers.
Thank you, Simon. Thank you all.